Good morning. Welcome to the First District Court of Appeals. We have 3 cases scheduled to be argued this morning. I will call the case. When I do, please stand, state your name, the party that you represent, and your readiness to proceed. The first case this morning is C-25-0130 and 131, State of Ohio versus Marcus Hardin.
Ms. Marcus Hardin, ready to proceed.
Good morning. Good morning. And yes, you may come forward, that's fine. The second case this morning is C-25-0194, State of Ohio versus William Graves.
Elizabeth Conklin on behalf of William Graves, the appellant. We're ready to proceed.
Morgan Wessels on behalf of the State of Ohio, the appellee. I'm joined today by Ms. Maya Chess, our legal intern. She'll be the one participating in the oral argument today with the court.
That is granted.
And we're ready to proceed.
Great, thank you. And the third case this morning is C-25-0175, State of Ohio ex-rel Attorney General Dave Yost versus Elevate Smoke.
Drew Smith for Attorney Yost, we're ready to proceed.
Morning, James Frazier for Elevate Smoke. We're ready to proceed. Thank you.
Great, thank you. All right, the first case is State versus Hardin. Mr. Hardin, you may come forward. You'll have 15 total minutes to argue this morning. You'll go first and last. You can divide up your 15 minutes however you like. Most people take 10 or 12 minutes to begin, and then 5 or 3 minutes to reserve. How much time would you like to reserve?
We'll do 5 minutes, Your Honor.
5 minutes. All right. You'll see lights in front of you on the stand there. They're green, yellow, and red.
Yes,
I'm going
ma'am.
to turn on the green one right now.
Yes, ma'am.
When you have about 1 minute left, the yellow light will come on, and then the red one will come on when it's time to stop, and I'll let you know that orally as well, okay?
Yes, ma'am.
All right, you may proceed when you're ready.
Good morning, Your Honors. May it please the court. My name is Marcus Hardin. I stand before you today after more than 20 years seeking justice. Justice that was denied when I was deprived of my constitutional right to effective assistance of counsel and right to trial. Although this case is more than 20 years old, there's no time limit or statute of limitations on our constitutional rights. And Ohio Revised Codes 2953.21 and 2953.23 allows me to not only bring forth my claims, but in my case, be granted relief. This appeal is brought forth because of the trial court's denial of my post-conviction relief petition and the denial of my claim without an evidentiary hearing, therefore denying me and at the same time violating my constitutional right to effective assistance of counsel and my right to trial. Before I begin, is there any questions or clarification that anyone may need from me?
I'd like to know, Mr. Hardin, from your perspective, when it was that you realized that you could not expunge the conviction.
2012.
Okay.
2012. After doing my 5 years of probation, I was told to wait 3 years until, 2012.
And what efforts did you take at that point to try to remedy the situation?
I've been searching for lawyers throughout the state of Ohio and northern Kentucky for the past 13 years. Obviously, with no help, I'm here today, pro se. Again, it wasn't until 2023 that I learned of the Sixth Amendment and effective assistance of counsel. And from there, I proceeded to take the route of post-conviction relief.
All right, thank you. That's
ma'am.
helpful. Thank you.
Yes, ma'am. The state relies on 2 procedural defenses, jurisdiction and res judicata. The state argues that the trial court lacked jurisdiction because my petition was filed outside of the filing window. However, under Ohio Revised Code 2953.23, trial courts have jurisdiction to hear post-conviction petitions outside of the filing window when A, the petitioner shows that they was unavoidably prevented for discovery of the facts upon which the petitioner must rely to present the claim for relief or subsequent to the period, and B, the petitioner shows by clear and convincing evidence that, but for constitutional error at trial, no reasonable fact finder would have found the petitioner guilty of the offense of which the petitioner was convicted. Part A, my claim presents newly discovered evidence that wasn't revealed until years after my plea, such as the lie regarding expungement eligibility and my attorney's hidden addiction and misconduct that eventually led to his disbarment. This wasn't an issue visible in the trial record. It was hidden from me as it was from the public and the courts. None of this was discoverable at the time and therefore should satisfy Part A. The law recognizes that truth sometimes takes time to emerge, especially when hidden by a trusted lawyer, and post-conviction relief is the very remedy intended for such situations. Additionally, equitable tolling applies here because it was impossible for me to bring this claim during that time. Part B. This case isn't about what a fact finder could have concluded, as there was never a trial. It's about whether my plea was voluntary and informed. Under Hill v. Lockhart, when a guilty plea results from incorrect or misleading advice from counsel, and a person who have gone to trial otherwise, that is ineffective assistance of counsel.
Mr. Hardin, I
Yes,
have
ma'am.
another question for you. Are you representing that if you had known that this was not going to be expungible, that you would have done something else
I
besides?
would have went to trial. Took the stand with the trial. I would not have laid down like that.
All right, thank you. That's also helpful. I appreciate it.
Yes, ma'am. Lee v. United States reaffirmed this. Even when the evidence is strong, if someone pleads guilty because their attorney lied or gave false advice, and they would have insisted on trial if told the truth, their right to effective counsel was violated. That's exactly what happened to me. My lawyer assured me I could get the conviction expunged if I took the plea deal. That assurance directly led me to give up my constitutional right to trial and accept the plea deal. That assurance turned out to be a lie. Let's not forget why a plea bargain was even an option, which is because of Mr. Lawson's hidden addiction that compromised his ability to ethically and effectively defend me. So, under Hill and Lee, my plea wasn't voluntary. It was a product of ineffective assistance, and my Sixth Amendment rights were violated. The state also argues that res judicata blocks my claim, suggesting I should have raised it earlier. Simply put, I can't bring forth what I don't know. Lawson's lies and misconduct wasn't suspected nor known at the time by anyone, including the courts, and wasn't revealed until years later. Also, Ohio courts have long recognized that res judicata does not bar ineffective assistance of counsel claims that depend on evidence outside the trial record. This principle remains firmly embedded in modern case law. State v. Collins, 2024, Ohio 5112, paragraphs 73 to 74 from the First District. State v. Agee, 2016, Ohio 7180. And the Fifth District has stated outright that res judicata will not bar a claim of ineffective assistance of counsel if it is based upon evidence that holds the record. That is State v. Nelson, 2024, Ohio 1792, paragraph 17. So these cases make it clear that when a defendant's ineffective assistance claim depends on evidence not contained in the trial record, as here, res judicata is no bar to relief. My assertions are not speculative, nor are they coincidental. They are directly consistent with Lawson's long documented pattern of professional misconduct during the very years in which he represented me. The Ohio Supreme Court has repeatedly found that Lawson engaged in dishonesty, neglect of client matters, failure to communicate with clients, and conduct fueled by substance abuse, ultimately leading to his indefinite suspension and disbarment. Now, concerning the lack of affidavits on my part, during the earlier stages of this post-conviction relief, I didn't know what an affidavit was. However, I did submit notarized statements from both me and my wife, stating my attorney had lied to us about the plea deal. Later, when I understood what an affidavit was, I proceeded to submit proper affidavits from me and my wife. Unfortunately, the court struck those affidavits for being submitted too late. The cases the state cites involve claims that could have been raised earlier. In State v. Christopher Smith, as mentioned in my brief, the defendant and his family immediately recognized Lawson's lies and deception. In my case, the deception was hidden. In hindsight, it's clear Lawson exploited vulnerable people, including me. It's hard to recognize ineffective counsel when you're not trained to do so and you're unfamiliar with court proceedings and lawyer ethics. And the very person harming you is the person you paid and trusted to protect you. Back then, I was simply a defendant relying on his lawyer. Now, I understand that this proceeding is not about proving innocence, but I must say I maintain my innocence and was never given a chance to prove it. No matter how great a plea deal may seem, There's no deals when it comes to innocence and constitutional violations. The proper thing to do is to correct such violations. That's what justice is, and that's what the law calls for. My family stands with me today, including my son, the child directly affected by this case. Their presence shows their support in me seeking justice. I ask this court to reject the state's procedural defense and allow my claims to be heard on its merits. This case isn't about technicalities. It's about correcting a violation of my constitutional rights, a violation caused by a lawyer who should never have been advising anyone. No one should lose their right to trial and be forced to carry an unlawful conviction because of their attorney's hidden addiction and/or lies, as affirmed in Lee v. United States. With that, I respectfully ask this court to vacate judgment and/or remand with order to grant post-conviction relief.
Thank you.
Yes, ma'am.
You can have a seat, and we'll call you back up when it's your rebuttal time.
Yes, ma'am.
Thank you. Good morning.
Good morning, Your Honors. Good morning, Mr. Hayden. May it please the court. Your Honors, it's important to remember why we're here this morning. I commend Mr. Hardin for being here and speaking about his experience in these past 20 years. But the trial court didn't have jurisdiction to entertain his petitions for post-conviction relief under the mechanism that he chose to present his claims. Under 2953.21, as Mr. Hardin explained previously, any person who has been convicted of a criminal offense and claims that there has been such a denial of their rights as to render the judgment void or voidable under either the Ohio Constitution or the United States Constitutions is allowed to file a post-conviction petition asking the sentencing court to vacate or set aside the judgment or sentence. That is true. That mechanism does exist. However, this is not an unlimited time frame that someone can use to take advantage of this mechanism. Mr. Hardin he never appealed his conviction, so there's no question that filing 20 years after being convicted makes his petition untimely. Under 2953.21, if no direct appeal is taken, a petition must be filed no later than 365 days after the expiration of the time for filing the appeal. That was not done here. I understand that the legal system is difficult to navigate, especially for a non-lawyer, but 20 years has passed. Even if it was found out that he was ineligible for expungement in 2012, time has still passed.
Counsel, did
Yes.
he ever file a motion to withdraw his guilty plea based on this information that he's conveyed today?
Not prior to these petitions, no.
Did he file it in conjunction with the post-conviction petition? Or was this just a post-conviction petition?
Both of them were petitions to vacate under the same statute number, as far as I understand. I will say in the briefings that I submitted to the court that there was a misunderstanding of the law on my part of how I read the statute prior to this oral argument. Although the conclusion is true that the trial court did not have the jurisdiction to entertain these petitions, my argument was the wrong direction that I took for that. What I was confused about at that time was, what kind of conviction we're working with here. And Mr. Hardin had pled guilty during his conviction. So for him to file an untimely petition at that point under point 23, it would not be possible statutorily. So I did want to be upfront that I was mistaken with my briefing. But of course, I won't go through those arguments unless the judges have questions about that. But I wanted to be honest. The state will honestly submit with the briefings. The trial court was not mistaken, and their decision should be affirmed that they could not look into this situation, even if based on the merits. Unless there's any other questions.
Thank you. All right, Mr. Hardin, you have 5 minutes remaining.
Yes, ma'am. Thank you. I lost my argument. Again, 2953, 2953.23, at least what I've seen, is no time limit Again, the courts understand that sometimes it takes time for the truth to come to light.
Mr. Hardin, did
ma'am.
you ever seek to withdraw your guilty plea based on the information you've conveyed to us today?
No, ma'am, I did not. When I first started seeking expungement, there's no help that was given to me, no sense of direction, nobody was leading me to.
And did you file a formal expungement application and that was denied?
I did not. So when it was time for me to start filing for expungement, I started calling around, trying to figure out exactly how to do it. And they started telling me like, hey, you can't get this expunged. I explained to them that, hey, my lawyer told me I could. They're like, no, you can't get this expunged. So again, from 2012 until 2023, I was seeking expungement. When I learned that the ineffective assistance of counsel and the Sixth Amendment in 2023, I knew that was the proper way to go, and therefore I filed the post-conviction relief petition.
And when was it that you learned about your attorney's situation?
So it was later. I started hearing little things, but in 2023, I knew I needed to have evidence. The first thing I seen was a news article. I knew that wouldn't be enough. So I found his disciplinary hearings, and when I seen that, it just, everything made sense to me then when I seen his disciplinary hearings. And so that was in 2023. And I filed right away, maybe a little too early because I should have, built up a little knowledge, but I filed right away as soon as I found out.
Thank you.
Yes, ma'am. Your Honors, before I close, I ask you to consider the unique nature of this case and the lasting damage left behind by Mr. Lawson's addiction. While he's gone on to rebuild his life, now co-directing the Hawaii Innocence Project, his former clients, like me, are still living with the consequences of his misconduct. The system may have moved on from Lawson, but seems to have forgotten about his victims whose lives he has turned upside down. And that's why I find it especially important to mention that the state's own representative, Ms. Ada Nalian, excuse me if I'm pronouncing it wrong, has built her career advocating for second chances. At the Ohio Justice and Policy Center, she led efforts to help people overcome the barriers of a conviction. She's spoken publicly about her commitment to the disenfranchised, to people like me. And this isn't abstract. Just last year, in this very court, in front of Judge Kinsley, she fought for a CQE on behalf of someone charged with the same offense I face, endangering children, because she understood how a conviction like this can block a person from employment, dignity, and redemption. And again, let's also not forget about the civil liberties, such as the Second Amendment right to bear arms, that was unknowingly forfeited in my case. I stand here today asking for fairness. Mr. Lawson was given a second chance. Ms. Ada Nalian has fought for second chances. I'm simply asking for my first, the opportunity to finally correct a conviction that was built on lies, not justice. For the past 13 years, I've been seeking the moment to finally address my case. I've been turned down from countless lawyers throughout the state of Ohio over the past 12 years while seeking help. This has been a debilitating ball and chain that has robbed me of great opportunities and happiness. I'm here seeking justice because I owe this to my family and I owe it to myself. With that, Your Honors, I respectfully and humbly ask that the court to reverse the trial court's decision and vacate the judgment and grant post-conviction relief. If I may, now Mr. Lawson is still attempting to gain his license back after being denied reinstatement, I think last year, maybe the year before, including suing the Ohio Supreme Court in order to do so. I would like to state on record that Mr. Lawson should be continually denied reinstatement of any sort. Mr. Lawson only cares about how his addiction impacted his life.
Mr. Hardin,
Yes,
you're
ma'am.
close to your time. If you could wrap up, please.
Yes, ma'am, yes, ma'am. Mr. Lawson only cares about how his addiction impacted his life with no acknowledgement of the clients he neglected. Although empathy can't be taught, empathy of the lives he affected should be something that goes hand in hand while on a path of accountability and redemption. In my opinion, again, Mr. Lawson lacks empathy and accountability and should continue to be disbarred. Thank you.
Thank you very much. Thank you both for your advocacy and arguments this morning. We will take the matter under submission and we will issue a timely decision. Thank you. The second case on the docket this morning is C-25-0194, State of Ohio versus William Graves. Would you
Morning, Your
like to
Honor.
reserve time for rebuttal?
Let's go with 5.
All right.
Morning, Your Honors. Elizabeth Conkin on behalf of the appellant William Graves. In his appeal, Mr. Graves argues that his conviction for burglary is against the manifest weight of the evidence and also based on insufficient evidence. After a bench trial, the trial court found Mr. Graves guilty of burglary. I'm focusing specifically on the element of burglary that calls for a finding beyond a reasonable doubt that Mr. Graves committed trespass. In his decision, findings of fact, the trial court found that Mr. Graves committed a trespass specifically by kicking in the door and entering Ms. Bolton's apartment in that manner. There was no other basis for a finding that he committed trespass. And it's our position that the evidence upon which he relied was both incompetent and incredible. The evidence upon which he relied was solely based on Ms. Bolton's testimony. She was the alleged victim in this case.
Well, counsel, wasn't there pictorial evidence as well of the damage to the door? I realized that the testimony couldn't be placed in terms of time of that damage, but wasn't there some visual evidence as well?
Yes, and we're not disputing that there was damage to the door. The problem is, the officer who responded, Officer Anderson, had testified that she had responded to similar situations where she was called to inspect a damaged property committed by a perpetrator. And in this case, she inspected the door and could not determine whether any of it was caused recently. That there was old damage, but there was such extensive damage. There was no place where she could point to on the door that she could say was caused recently. So, although there were pictures of damage, there was no testimony other than Ms. Bolton's that any of that damage was caused by Mr. Graves. Officer Anderson did not corroborate her testimony on that point. And the reason that
Okay, didn't the officer, and I realize there's no time frame here, but didn't the officer testify that the damage was consistent with a forced entry?
But there was no testimony as to when, other than from Ms. Bolton, as to when a forced entry might have occurred. It could have been a prior forced entry. We don't know how long Ms. Bolton lived in that apartment. That damage could have predated her residency there. It could have been caused, maybe it was caused by Mr. Graves on a prior occurrence, but he's not accused of committing that offense of trespass by kicking in the door on any other date than October 19th, 2024.
But couldn't a reasonable fact finder infer that it happened that date?
And that's where we get to Ms. Bolton's testimony, that it was both incredible and incompetent based on her prior inconsistent statements by omission when she was calling 911 when Mr. Graves was actually in the apartment.
So,
on the
in
24th.
regard to the 911 call, it seems like there's a great dispute, or at least perceptual dispute about what was happening at the time of the event, and it seems like he was trying to make himself out as the victim on the 911 call,
He said that she was stabbing him.
and then he left the scene before the police arrived.
He did.
So isn't that inconsistent with someone who wants to explain that they're the victim?
Well, but that's not before the court right now, Your Honor. I think whether Mr. Graves stayed around to pursue a claim that Ms. Bolton had actually assaulted him doesn't determine whether her testimony regarding his behavior is
But
credible.
she initiated the 911 call.
She did, and she admitted during direct examination, not cross-examination, that she called 911 because she was tired of arguing with him. That was her testimony at trial. And that's borne out by the 911 tape, which is 6 minutes long. For 6 minutes, not one time during that call did she say that he had kicked in the door. She didn't say she was afraid of him. She didn't say that he was doing anything other than that they were tussling and that he was trying to take her keys. There was nothing in that 911 call that suggests that he entered that apartment by kicking the door in, or that he was there without permission.
Well, counsel, what about the argument that was made in the brief, and I expect will be made later today, that the 911 call is to report an ongoing situation, and therefore it wouldn't necessarily be intuitive for the prosecuting witness to report what had already happened?
Well, I would think that in a 911 call, if someone has kicked in my door, that would be something you'd want the police to know, because it heightens the level of the urgency. Someone in your apartment arguing with you and trying to take your keys doesn't rise to the level of concern or immediate threat to her without the information that he has allegedly kicked in the door and forced his way into her apartment. At no point did she say that. And she was on the phone for 6 minutes. It's not like he wrenched the phone away from her before she had a chance to get that information out. This is all happening in contemporaneous time with him being in the apartment. And again, on the 911 call, she doesn't display any emotion. She talks calmly to the operator. I am tired of arguing with him. He is being dramatic. And so the failure to allege that she is being confronted with someone who has kicked in her door while she has the 911 operator on the phone is indicative of the fact that she lied in court. The only time, the first time that she made that claim was after Officer Anderson had handcuffed her because they thought that she was the aggressor. The first time.
And so it's self-serving in your perspective?
Yes, it's self-serving. And then the failure to want to prosecute is also indicative of her realizing that this has gotten out of control.
And wasn't there conflicting information about the prosecuting witness's desire to go forward?
There wasn't. In both of the bond hearings, appearances in court, both attorneys, specifically the prosecutor, said it is the complaining witness's desire to dismiss the charges and or to have him released on bond.
Did she actually make that representation herself?
To the prosecutor.
But she didn't make that representation in court.
She was not asked to make the representation in court. She was not addressed by the court. But this prosecutor made that representation to the judge. It is true that the complaining witness has told me she wants to dismiss the charges. Clearly, we're not going to do that. It was the prosecutor's decision to pursue the charges, even after the complaining witness had indicated that she did not want to pursue them, and that she had told Mr. Graves' attorney, which she ultimately admitted during cross-examination and trial, that it was a misunderstanding. And so our position is that where the evidence regarding the trespass, whether he kicked in the door, is based on incompetent and incredible evidence, that it was against the manifest weight of the evidence to find him guilty of burglary based on that specific finding. And for that reason, we ask that you vacate the conviction and either discharge him from responsibility in further prosecution, or in the alternative, remand it for a new trial.
Thank you.
Thank you, Your Honor.
morning, Your Honor.
Good morning.
My name is Maya Chess. I'm the legal intern on behalf of the state. So before I begin, I wanted to ask if there are any questions the court would like me to answer. Okay. So first, I would like to address a question that Judge Kinsley, you had asked opposing counsel, asking if there was any visual evidence as well as the testimony that Ms. Bolden provided at trial. Opposing counsel says that the evidence presented, besides the testimony, were pictures that showed both extensive old and new damage to the door. However, opposing counsel fails to point out as well that there was a broken lock on the door as well that aligns with her testimony. Not only that, there was a 911 call in which, although opposing counsel says that there really was no level of urgency, there was on the 911 call. And in that 911 call, I would say that Ms. Bolden did not need to point out specifically injuries to her hand, the kicking at the door, him coming in her home, because given the totality of the circumstances that she was facing with him yelling over her, saying, "You're going to go to jail," trying to get her to go to jail by yelling at her on the phone call, she was in disarray, and this man was actively taking her keys, which the court in its entry actually found had happened. So they rendered their decision based on all the evidence presented.
Isn't it true, though, that the officer in examining the door wasn't really able to say when the damage occurred? Like, there was extensive damage to this door and some makeshift repairs, and the officer couldn't really tell what was old and what might have been new, or even if any of it was new.
Your Honor, that is correct. The officer did say that it looks like there had been maybe old and new damage. However, upon examination at trial, when asked about the door, the officer actually said, from what Ms. Bolden had described upon investigation about Graves kicking in the door, the pictures that they had shown is actually consistent with her story. So the officer at testimony testified to this in court.
Was the lock a new lock? Is there any testimony or any information about, any evidence about the lock? My understanding is maybe there were multiple different times where the door had been broken into. Was the lock a replacement lock?
Your Honor, she did testify that before that day on multiple other occasions that Mr. Graves had come and kicked in her door and there was some old damage to the door. I cannot recall whether the lock was immediately new right before that. However, upon her testimony, Officer Anderson's investigation and the pictures, the lock was clearly taken off the door. And even at the bottom of the door, there were kind of the metal lifting at the bottom of the door, kind of consistent with her story of Graves kicking it in and her having to hold her foot behind the door, especially since the door swings in. So as it swung in, the lock was broken off and there was damage to the bottom of the door with the metal lifting up.
What about this argument that she didn't disclose that he had broken the door in until she was in handcuffs and she was facing potential prosecution? I mean, is it self-serving that she then reveals that he broke into her apartment?
Your Honor, I don't believe so, only because upon Officer Anderson's investigation, when he was called there for a stabbing, he initially handcuffed Ms. Bolden because he wanted to secure the scene, and also he was expecting maybe a body laying around, because that's when a stabbing occurs. There might be a body, there might be blood, there might be a sharp weapon. However, he didn't find any of those things, firstly. And second of all, Mr. Graves also fled the scene after taking her things. If Mr. Graves was actually stabbed and needed medical attention, which there was no medical records, he did not call 911 for medical attention for the stabbing.
Is that an issue in this case, whether he was stabbed?
Your Honor, no. I do not believe that is the main issue. The main issue is whether he had broken the door down with force, trespassed into her home without her permission, and took her things and left, which is what the court found, again, in its entry, is what he did. Now, the second thing I would like to highlight is the question that Judge Kinsley, you had asked was, wasn't there conflicting evidence of the victim going forward in court? Opposing counsel uses this to undermine Ms. Bolden's credibility and calling it a part of the linchpin of the state's case. However, in this case, first, I would like to say that the court can believe all, none, or some of the witnesses' testimony in order to convict. Also, the court may rely on one witness's testimony alone and find it credible in order to convict. But that is not all we have here. As I mentioned before, there is a 911 call, the body cam, Officer Anderson's testimony, and pictures. But in regards specifically with Ms. Bolden's statement on whether or not she wanted to go forward, she clarified in court upon cross-examination that she only wanted Mr. Graves to get lesser charges, not that she wanted the charges dismissed. She may have had a conversation with the prosecuting attorney, and the prosecuting attorney did say on record that it was her preference to have the charges dismissed. However, that is not her sworn statement in court.
Even if true, does that impact whether the weight of the evidence supports a guilty finding? I mean, does that speak to just her desire of outcome, or does that speak to what the evidence is in the case?
That more so, Your Honor, speaks to her maybe desire of the outcome. However, when viewing the weight of the evidence, we have to weigh the totality of the evidence, the totality of the circumstances, which, as I mentioned, was the 911 call, the body cam, the officer's testimony, and her testimony in court. And although we have other evidence that aligns with her story, the court can determine her credibility based on her testimony alone. And under the manifest weight standard, this court may give discretion to the trier of fact, which is the judge in this case, who found her credible.
Was she cross-examined on this aspect?
Your Honor, what aspect specifically?
That she wanted the case dismissed, or that it was a
Yes.
misunderstanding?
Yes.
And that's when she basically said she had some reservations at the beginning, but she was willing to go forward, and that's why she was there that day for trial?
Her specific words were she wanted him to get lesser charges, and he had called her from jail prior to that, asking her to get the charges dismissed. And at the time, she said after he called her, he didn't believe, maybe he didn't deserve it, but his actions didn't change. So not necessarily that she wanted the charges dismissed, Your Honor. If there is nothing further, Your Honor, I don't have anything more to say.
Thank you. Thanks very much.
Thank you.
Thank you, Ms. Chance.
With regard to the claim that the door lock was broken, I think it's important to note that when Officer Anderson testified, she said, and I'm assuming this is a woman based on the name, but I could be wrong. Officer Anderson testified that the door was closed when they arrived in responding to the call, and that they knocked hard on the door to announce their presence, and the door did not open. It remained closed. So I think that goes to whether the lock was actually broken, but the door was able to be closed, and it was closed, and it remained closed when the officer knocked on it. I would also point out that Officer Anderson, on cross-examination, acknowledged that the testimony that Ms. Bolton gave was not consistent in total with the information that Ms. Bolton provided Officer Anderson at the scene. Specifically, Ms. Bolton's testimony at trial that she was up at the door, arguing with Mr. Graves through the door, and that when he was kicking it, according to her testimony, she put her foot up against the bottom to try to keep it from opening. She never told Officer Anderson this information. In fact, when she talked to Officer Anderson at the time that Officer Anderson responded to the call, Ms. Bolton indicated that she was across in the living room when this was happening, and that never mentioned that she had put her foot up against the door. Just another inconsistency in her various versions of what happened on that day.
All of those things are just really about her credibility as a witness. It's
Absolutely.
So it all comes down to, in the manifest weight, the determination of her credibility.
I agree with you that this is primarily a manifest weight argument, although I think you could argue that the evidence is so inconsistent and so incredible and so incompetent that you could find that it doesn't rise to the level, you can't believe it. There's so many versions that she gave, even on the witness stand, that prevent a finding that this element of trespass was proven beyond a reasonable doubt if you rely solely on the basis that he kicked in the door as the mode of trespass. And then with regard to the stabbing and the fact that he didn't stay around to make the report, it is, I don't think, relevant to the issue of whether the state proved beyond a reasonable doubt that he committed a trespass by breaking in the door. There was testimony, I believe, or at least in the 911 call, where Ms. Bolton said, "Stop wiping your blood on me." And that when she said that there was blood, and when the officer noted that there was blood on her, I think Ms. Bolton said that was his. So there is a possibility that he was actually injured to some degree during this altercation, whatever it was, argument. But,
Was there testimony that it was from the tussle over the keys?
oh, it entirely could have been, because there was no evidence at trial that she stabbed him, but that doesn't mean it wasn't happening. But based on our position in our briefs and today, I believe that the evidence is against the conviction is against the manifest weight of the evidence based on her inconsistent and incompetent testimony, and that it was error for the trial court to find him guilty of burglary, and that should be vacated. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. The final case we will hear this morning is C-25-0175, State of Ohio ex-rel Attorney General versus Elevated Smoke. Good morning. Would you like to reserve time for rebuttal?
Yes, Your Honor, I'd like to reserve 2 minutes for rebuttal.
All right.
Thank you, Your Honor. May it please the court. The state of Ohio filed a complaint for violations of the Consumer Sales Practices Act for the deceptive sale of unregulated and illegal vaping products. And that's what brings us here. Appellee was in violation because he failed to clearly and conspicuously disclose the illegal and unregulated vapes he sold were not legal or regulated, took advantage of the consumers to protect their own interests because the consumers had no way of knowing that the products were illegal and unregulated.
When you say unregulated, what do you mean? I mean, aren't these products regulated by the FDCA?
These products were not regulated by the FDCA. They were outside the FDCA.
Well, isn't a part of your claim that they're unlawful to sell under the FDCA?
That is correct.
And
They are unregulated.
so then
and
wouldn't
unlawful.
that be a regulation that applies to them?
Well, it would be a regulation that applies to them, but that is probably the correct way to put it. They are illegal to sell because they have not been examined by the FDCA and they are not accepted by the FDCA for sale. They have no idea what's in them. And that's why they're illegal to sell in the United States. They're
So
considered adulterers.
is the state of Ohio's problem more so that the federal government is not enforcing its law?
No, the state of Ohio's problem is different. The state of Ohio's problem is the fact that they're deceptively being sold in the state of Ohio.
What
That's
is
where we come in.
what is the deception? What deception would you prove if you had a trial?
The deception I would prove is these vaping products that are unexamined and illegal are presented in these stores, this store in particular, and other stores as well with regard to our other appeals, among vaping products that are legal to be sold. There's no way for the consumer to decide, do I want to go down this path, where we don't even know what's in these vaping products, where they're not examined or looked at by the government, and they're amongst and in between
What have you
vaping
alleged
products.
that the store is doing other than putting the product on the shelf?
They are putting the product on the shelf amongst other products on the shelves that are legal and they know what's in it. Everyone's been to these.
So it's adjacency, it's an inference by adjacency to other products?
It is it is presented in a way that the consumer would have no idea what it is. They would have no idea what the difference is between the products being presented that are both legal and being regulated, being examined, and these products that are just, it's like moonshine next to vodka.
And how is that? I want to really drill into that so
Sure.
that I understand the nature of your claim. How is that? So where is the customer deriving its information from in this store?
The customer presents themselves to the store, and they look across the counter, and they see all these vaping products that are available to them. Only 27, it may have grown a little bit, vaping products are legal to be sold in the United States.
Because of the FDCA.
Because of the FTCA.
And,
But they're being presented together as if they are the same thing, and they are not. And that's the deception we have here.
But
So
where
are you-
is the customer getting its information from?
From the store, when you're looking at products that are being presented as something that they are not, because they're presented together. There's no way,
It's just the product on the shelf, that's it.
the product on the shelf, and there's also this labeling issue that occurs as well that says allowed to be sold in the United States when it is not.
All right, so
So-
it's the label. It's the
No,
label
it's-
that conveys the information.
The label conveys the information, and the store conveys the information when it's presenting these products as the same as legal products.
So let me, I'm trying to make sure I'm understanding the nuance that I believe you're arguing. So what you're saying, it isn't, the label itself is not necessarily the issue. The issue is that that the store is not providing information to the consumers.
Correct.
So what is it that you are, in your mind, what would be sufficient?
What would be sufficient if these products were available, which they should not be, okay, and the FDCA or the FDA continues to sleep on the job?
well, isn't that really the state's, it just seems to me that the federal government could bring an enforcement action. You
Sure they could.
concede that the United States could bring an enforcement action, and then just, from Ohio's perspective, sitting on their hands.
Well, they could bring an enforcement action, but they don't. And here's the other thing. What the difference is between what the FDA could do and what we can do, the FDA can decide that they're not going to be on the market, okay? That's their prerogative.
So could Ohio, though, and Ohio hasn't passed any standalone regulation of these vaping products, right?
Well, I can't help with the legislature, but regardless,
Right, because you're the executive branch, and
Exactly.
Ohio hasn't legislated in this area.
but we do have the CSPA, and that's where the difference occurs. The difference occurs, you've got the FDA with the ability to remove the product from the market. The executive branch, we have the ability to make sure that these products aren't sold deceptively. That's our prerogative. That law is on the books.
But that law doesn't really say anything about tobacco products, right? It's just a general law of the state
Correct.
of Ohio.
Yes. Anything can't be sold deceptively. That's correct. And this is one of those things. They can't be sold deceptively. And so we're looking at this, when my 21-year-old child, I say child, adult, sorry, still a kid in my mind. When a 21-year-old goes in there and she decides to buy a vaping product, then she goes in there and she looks at all these vaping products and says, I like watermelon. I like the taste of mint. Well, as far as she's going to know, both because of where they're presented, okay, the way they're presented, as if they are anything else, and also the fact that if she does get it across the counter, she reads this label that says, for sale allowed in the United States. She can, in no way to protect herself from an unregulated vape that's coming from a foreign land that they have no idea what's in it.
That's a federally mandated label, right?
Well, that's another issue here. They argue that it is. I say that it's not. The only evidence that they presented was...
It's not evidence. It's not evidence. It's a textual reading of the federal law.
Okay, if you want to look at it as a textual reading of the federal law, then you have to look at it under the Loper analysis and whether it should carry any weight.
I'm not asking for any evidence of any agency interpretation. I'm just looking at the text of the words on the page.
Okay.
And they say that tobacco products sold in the United States must carry this label.
So you're looking at the statute?
Yes.
Okay, well, let me just present this with regard to the statute. An unauthorized e-cigarette is adulterated as a matter of law. The FDCA prohibits the introduction or delivery for introduction into interstate commerce any tobacco product that is adulterated. The FDCA requires the tobacco products other than cigarettes for introduction and delivery for the introduction to interstate commerce in the United States shall bear the statement for sale only allowed in the United States. Their interpretation of the statute is simply this, that e-cigarettes in question, the e-cigarettes that are adulterated under federal law and are prohibited to be introduced into interstate commerce are required to have the label so that they are allowed to be introduced into interstate commerce when they are illegally introduced into interstate
Well,
commerce.
doesn't the federal statutory scheme create two different areas of noncompliance? One is selling the adulterated products, and two is selling unlabeled or mislabeled products. Those are two different areas of regulation.
They are both considered adulterated products. And it's a bootstrapping argument in my position, Your Honor. It's an argument that says, because these need to have this label to be introduced into commerce. These are not allowed to be introduced into commerce. That's why the label does not make any sense. And what we have is two different choices in terms of the interpretation of the statute. One that leads to this result, where you have this label that says allowed to be sold in the United States when it's not. The other interpretation, which is the state of Ohio's interpretation, says, no, that's a bootstrapping argument. These aren't allowed to be entered, so we don't even get to the labeling
Isn't
issue.
there a different way of looking at the labeling requirement, which is that it is informing consumers that the product isn't authorized for international sale?
That they're not authorized? Well, I think that a consumer, and we may disagree with this, Your Honor, for sale allowed in the United States, I'm not thinking internationally. I'm thinking it's allowed to be sold here, and that's a fallacy. It's not true. And that's why my interpretation of the statute, Your Honor, I would argue is a better interpretation. Because I think it's safe to say the FDCA, the FDA, does not want their labels that is allowed to be sold in the United States on the market when it's not.
Okay, so you are arguing a lot about what the federal statute requires or doesn't require.
Sure.
And there is case law out there saying that a state law claim is prohibited if it wouldn't exist in the absence of the federal statute.
That's correct.
So I'm just wondering how your claims survive.
Okay, so I understand exactly what you're saying, Your Honor. They relied on Buckman and Loretto. Those are the two cases that they relied on. The problem is with that idea is if you rely on that alone, saying that referencing the FDA makes it so that we're impliedly preempted.
It's not just referencing though. That's the basis. If these products were not adulterated products, would we even be sitting here?
Well, it is somewhat the basis, but if you look at the Vape Tech case out of a federal district court and the Wisconsinites case, my supplemental authorities I submitted to this court, I think that's the correct view. The cases that they relied on weren't on point at all. First of all, they were private individuals. They weren't state action. They didn't interpret the statute. They didn't look at the preservation clause or the savings clause. They didn't do any of that. They just looked straight at that specific situation. And in that situation, Your Honor, with regard to those cases cited by Appelli, they didn't have the preservation clause in that part of the statute. So that case that doesn't have a preservation clause protecting state action, which is what we have here. So those cases are far away from what we're dealing with here. First of all, state action. Secondly, a preservation clause. And also a savings clause. There was none of that in the statute being analyzed in Loretto or Buckman, which is the cases they relied on.
Isn't this case measurably different from Wisconsin and North Carolina because Ohio does not have any freestanding regulation of the e-cigarette market, and those two states do?
Well, I don't think it is a difference because I think we're allowed to enforce the laws that are on the books, and we're forced, whether it be direct and dealing specifically, or whether it be a Consumer Protection Act. When you deal with a Consumer Protection Act, it's fine.
Doesn't the preservation clause specifically reference tobacco laws? Like, if Ohio had tobacco regulation, then maybe Ohio would be independently regulating in the field, but it seems like Ohio does not.
Well, thank you, Your Honor. It says enforce any law, rule, or regulation, any law
With respect to tobacco products.
or other measure with respect to tobacco products. Well, we are enforcing a law with respect to tobacco products, and that we're enforcing the CSPA. I mean, the CSPA.
I mean, but it
is a-
doesn't seem like it doesn't really reference tobacco at all, the Consumer Sales Protection Act. It seems to be a general law that is not specifically regulating tobacco. So it seems like the Preservation Clause would not preserve something that doesn't contemplate a tobacco law.
Well, I think when it says shouldn't limit the authority of the state political subdivision to enact, adopt, promulgate, enforce any law, rule, or regulation or other measure, I think that includes the CSPA.
And you're out of time.
Thank you, Your Honor.
Thank you very much.
May it please the court. Obviously, I'm happy to answer any questions the court has, but I want to address the labeling issue, preemption issue, and the preservation clause issues. First, on the labeling issue on this sale only allowed in the United States, I think you have to look at the entire statute. And I agree with the court that this is a legal issue. It's not an evidentiary issue. But the statute says all tobacco products must be labeled with a label that says sale only allowed in the United States. The FDCA also says that a tobacco product that does not have those words in the label is misbranded. And the FDCA prohibits the interstate distribution of misbranded cigarettes and subjects that person to criminal and civil enforcement actions. Also important when you're trying to determine, well, what did Congress mean when they said the label has to have the word sale only allowed in the United States? The state here is arguing that that is somehow tricking or misleading consumers into thinking that the product is approved by the FDA, authorized by the FDA. I don't think that's what Congress had in mind. The reason, and you have to understand that the labeling on tobacco products is not only for the consumers, it is also for parties within the distribution chain, including importation into the United States. And that's why you want to make sure that the label clearly says this is only to be sold in the United States. The labels, there's a couple of labels actually attached to the complaint in this case. And if you look at the labels of those products, they don't just say sale only allowed in the United States. It's got nicotine addiction warning. It's got the ingredients. My friend several times here this morning said nobody knows what's in these products. The products by law have to say what is in them. And they have other information that the Food, Drug, and Cosmetic Act requires. They also, the ones that are attached to the complaint have a California Proposition 65 warning because California state law requires those. In addition to that, if you look at another section of the Food, Drug, and Cosmetic Act, it's 21 U.S.C. Section 331, parentheses, lowercase tt. That is the prohibited acts section of the FDCA. That prohibits any tobacco product, anybody from making an implied or express claim that a tobacco product of any kind is approved by the United States FDA or that FDA endorses the tobacco product. Sometimes people get this sort of confused, where FDA does not approve any tobacco product. FDA approves drugs, they approve some medical devices. FDA authorizes some tobacco products, but FDA's position is there is no such thing as a safe tobacco product. There is no such thing as a tobacco product that is good for you. But Congress does not allow FDA to ban all cigarettes, and it is set up a process where the FDA can authorize new tobacco products if those tobacco products overall would be beneficial to the public health because they would help people use less of a more dangerous tobacco product.
Counsel, against that backdrop, are we to assume that Congress, number one, knew what it was doing when it required this sale-only label, and then number two, did so for a valid purpose?
Yes, Your Honor, that's exactly the point that you made much more concisely that I was trying to make, but exactly right.
And then what I'm hearing from the state in this case is that it perceives the purpose of the sale-only label when applied to adulterated products to be deceiving consumers in the marketplace. Does that cut directly against Congress's intent when it adopted the sale-only label requirement? In other words, Congress presumes this label to be informative in the marketplace, but the state of Ohio is arguing the exact opposite
I
in
think
this
that's
case.
correct.
And would that then frustrate Congress's purpose?
Absolutely, it would, Your Honor.
So, let me ask a somewhat related question. My reading of the state's argument, and actually, let me just go to the complaint itself. For most of the claims in the complaint, it seemed to me like it wasn't arguing that the label itself should be changed. It seemed to me like it was arguing that there needed to be something at the point of sale informing consumers that this was an adulterated product. Can the complaint be read that way?
I don't think that it, and apologies, Your Honor, it's been a while since I've looked at the complaint. Even if it were to be read that way, I don't think it would I still do not believe it would adequately state a claim. And apologies, but don't like to talk about myself, but I worked at the FDA for 5 years and understand how the FDA thinks about these things. And when you talk about the labeling of any FDA-regulated product, drugs, medical devices, whatever, the labeling is not just limited. Label is what's on the product.
Correct.
Labeling accompanies the product. So you can have labeling on a website. You can have labeling at a point of sale. And the FDCA says that states cannot add labeling requirements to tobacco products.
So a display or a sign or something actually at the point of sale in the store, you're saying that that is
That would be
included in labeling?
That would be labeling, and I believe that the preemption clause of the FDCA, which is cited in both sides' briefs, would say that, no, states can't do that. Because then, the FDCA requires, tobacco products to have labeling that talks about certain risks of nicotine being an addictive substance. That prevents the state from saying, well, we want something in addition to that or different than that about nicotine, so we're going to require that at that point of display. So I think that would be preempted. And still, at the end of the day, I think the important thing here is that under Buckman and Laredo, and it's not just Buckman and Laredo, but there's other cases that we've cited in our brief, including the case from Iowa, case from the Ninth Circuit, that our position is correctly rules that if the state's claim would not exist but for the existence of the FDCA, you are then enforcing the FDCA, and you can't do that under 337A. And that is best demonstrated by getting into a bit of the facts here. So electronic cigarettes.
Counsel, can I stop you
Sure.
there? So to that point that the state is really seeking to enforce federal power here, if we remove the FDCA, we just take it away, it's not on the books, is there any deceptive practice here at all?
No, and that was exactly the point I was about to make, Your Honor, is the electronic cigarettes became subject to the Food, Drug, and Cosmetic Act on August 8th, 2016. But there were already millions of electronic cigarettes on the market in the United States at that point in time. So if you think about it, August 7th of 2016, the state would have had no claim. August 8th, the state is saying, well, we now have a claim. That discussion right there just shows you that how this is just dependent on the existence of the FDCA, and that's what the state is trying to do.
If the state, and I realize I'm asking you to step into a hypothetical universe, But if the state were to pass a law that says we ban the sale of e-cigarettes in the state of Ohio, in theory, and I realize that could raise a whole host of other questions that are not in front of us today, but in theory, that would survive the preemption argument that we're talking about right now.
Absolutely, it would, Your Honor. And in fact, some states, California and New York, have banned flavored electronic cigarettes. But a state would be free, or a locality would be free to ban all tobacco products, just like some counties in the United States ban all alcohol. If there are no further
So
questions.
if there, let me just ask this. So the savings clause, when it says that the preemption clause doesn't reply to requirements relating to a sale, distribution, and a few other things, and then advertising, promotion, et cetera, if I'm understanding you correct, your argument is that if the state legislature chooses to enact a particular statute related to the sale, requirements relating to the sale of, or to advertising or promotion, then we have a completely different story than here, where the statute at issue, the statute that the state has based its claims upon, is a general statute related to consumer protection.
I think that's right, Your Honor.
Okay,
Yes.
I appreciate that clarification.
Counsel, would you have us affirm based on what the trial court said, or do you believe that the express preemption provision?
I would have you affirm, first and foremost, but obviously our brief made more arguments that the trial court did not address all of our arguments, but I believe that as far as the state is arguing that the product violated the state law because of the words sale allowed only in the United States, I would say that is barred by the safe harbor provision of the state statute. It is expressly preempted because the state is asking the defendant to change the labeling, which it is not allowed to do, and it is impliedly preempted because it would be impossible to comply with state and federal law at the same time.
And counsel, would you also agree that the state's interpretation frustrates the purpose of the federal scheme as well?
Absolutely, Your Honor.
I have an additional question for you. I understand that there are parallel proceedings in the 5th Appellate District and the 9th Appellate District in Ohio.
Yes, ma'am.
I checked those recently, and it's my understanding that they're both still pending without decision. Is that your understanding as well?
Yes, Your Honor.
And do they raise similar claims to this action?
Yes, the complaints were, I believe, and my colleague can correct me if I'm wrong, because he wrote the complaints, or somebody in his office did. I think they're identical complaints, other than the names of the products.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honors. They are identical complaints. Each court took a different little twist on it, so the decisions might look different, but they're based on the same complaint.
The one in Wayne County, I was able to find, it appears the trial court in that case relied on the CSPA's savings clause, or
Correct.
however you want to
Right.
brand that provision.
Yes, Your Honor.
What happened at the trial court level in the 9th District case?
The 9th District is the same reason here.
All right,
Yeah, the same reason here. Your Honor, I think the analogy for this is, while you cannot sell illegal or legal products in a deceptive manner, your illegality being separate, you cannot do it. And I would encourage this court to look at Vape Tech out of one federal court, and then also look at Wisconsinites, these cases, because the analysis being set forth here, and they actually mention our lower court in this case as being incorrect. And I think the federal court is right out there in saying that, look.
In which federal, in Wisconsin?
Wisconsin references this case in particular as being an incorrect analysis when they only applied Buckman and didn't look at the statute. The statute with the preservation and the savings clause.
well, counsel, even if we agree with you that the amended statute preserves a role for states to regulate, Ohio has not regulated e-cigarettes. You agree, right?
They have not regulated, but It does say other measure in the preservation clause, and I am suggesting to you, even aside from all of that, if there's a deceptive sale going on, it's a CSPA violation, and this is a deceptive sale. When you're presenting these products as something they are not, and the consumer has no opportunity to look at these products and make an informed decision.
And the
as to whether they
basis
want
for
that.
your deceptive sales claim is non-compliance with the FDCA, right?
And the fact that they are putting it in a position where you can't tell whether it is compliant or not. Yes, that is part of it. It is a reference to it. And if you look at those cases out of the federal district courts in the West, they'll explain that, yes, there's a reference to it, but we are not enforcing the CSPA, because what we're doing is enforcing the fact that they cannot deceptively sell. An example, and again, we're going into hypotheticals, where the appellee can abide, still sell it, but not deceptively sell it, would be, for instance, if they had a separate section, and it says unauthorized vaping products, just like those old movie rental places, which would have separate sections you could go into and go
Does
into the
that raise,
unauthorized.
does your proposal there raise any Fifth Amendment concerns?
In what sense?
Well, that you're putting a legal obligation on a business to hold out by words that they are engaged in a violation of federal law. Does that raise any Fifth
They
Amendment?
don't have to use those words that they're in violation of the federal law. They just have to separate these out so that the consumer can tell, okay, I'm into the Wild West here. I'm buying the moonshine, not the vodka. I mean, it's very similar as if you went into a liquor store, vodka, 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 moonshine, with a vodka label. It shouldn't be allowed. That is a deceptive sale regardless of the federal regulations with the tobacco folks. That's a deceptive sale of a product, because someone going in there all of a sudden has 150 proof of moonshine. I mean, this is the exact same thing. In this whole thing that, oh, they have to say what's in it. I mean, that's voluntary. I could put anything I want on that package, and I might suggest that some of these companies that don't bother, and know they don't have to bother now with the FDA, can put anything on that. That's self-reporting. That's not what this is supposed to be about. And
Counsel,
that's,
you're out of time if you'd like to wrap up.
okay. Your Honor, with regard to this case, I would ask that you remand this case and overturn the lower court's decision.
Thank you very much. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.